Welcome to our house. My name is Janice Raffle. I'm the manager and associate broker at Long & Foster in Rockville King Farm, and this is Joe Hansen.
Hi, Joe Hansen. I'm a managing attorney at RGS Title.
And we're here today to go through the GCAAR sales contract. So come with us, visit us, and if you have any questions, please don't hesitate to give us a call. In addition to that, be sure as we go through this video that you have a GCAAR sales contract in front of you, because that will help you as we go through the video. Thank you. All right, so we're going to start out with the contract, and the first part of it on page 1 is time is of the essence as to all terms of the contract. Joe, you want to explain what that is?
Sure. Time is of the essence basically means that if there's a deadline in the contract for a party to perform, failure to perform by that deadline could constitute a breach of the contract. So if something says something has to be done by 7 days or 10 days, the failure to do so can be a breach, and that goes to the settlement date as well. If a party doesn't perform at settlement date, that's a time is of the essence issue, and therefore they're potentially in breach. And that was actually just moved on the GCAAR contract. That used to be the last thing on the contract, and now it's the first thing, because that's how important GCAAR takes that time is of the essence phrase.
Great, thanks for that clarification. Sure. On the first paragraph, you're putting in the date of the offer, and that's actually when the offer is written. You then need to put in the buyer and seller's names. The buyer or seller, whoever you're working with, you put in there. If you're working with the buyer, you put in the name or names of the people you're working with. The seller's name you can get from the public record or the tax records, and that will also give you the real property information, which is on paragraph 1. If we scroll down to number 2, in Montgomery County, there needs to be a jurisdictional addendum. So you would check Maryland and you would put in Montgomery County if your contract doesn't auto-populate. Paragraph 3 is really putting in the prices. The way the contract is now is that it has the first part, the down payment, is a percentage. So for example, if you're financing 80%, you would put that the first trust is 80%. We very rarely do second trust, but check with your lender to see if that's appropriate. And very rarely does the seller hold back any mortgage. The total financing would be the difference between the amount that's being financed and 100%. So for example, if you are financing in the beginning 80, if you're putting down 20%, then the financing would be 80%, okay? First deed of trust, basically most people are obtaining that. We do very little assumed. Most of them are fixed rates, but check with your lender to be sure. You need to put the type of financing, if there's financing, and there are 3 choices: conventional, FHA, VA, or other, okay?
And I'll just to kind of pop in about the financing, that was recently changed. All those used to be dollar amounts where you would actually put in a set dollar amount for your financing, first trust, and then the total financing. They've moved it to a percent to make it easier for you, just in case you continue to negotiate or those types of terms change. If it's still an 80% loan, it's just an 80% loan. You don't have to go back and renegotiate the total loan amount anymore. And a reminder too that as far as paragraph C is concerned, the first deed of trust, and then it gives you the options as far as the conventional FHA, VA, as far as the addenda are concerned. Always make sure that the box is checked and the appropriate addenda are signed and attached to the contract. Otherwise, there's a potential argument to be made that you do not have that protection of the financing. All of the financing, all the contingency language in the GCAAR contract is contained on those separate addenda. So you have to make sure that everybody understands those deadlines and that the specifics of each one of those.
Great point, thank you. On number D and E, it's only you would be checking them if the buyer is going to be getting a second deed of trust, or on number E, an assumption. 4 is the deposit paragraph, and the deposit is the earnest money deposit. That's the good faith deposit. Joe, what can you say about that? What do you find most people are putting down?
Sure. It just kind of depends on each person's situation. It depends on the purchase price. I'll just say kind of the higher the deposit, I might kind of send it back to you. The higher the deposit, obviously, it shows a stronger offer generally to a seller. So if you have, a $20,000-$50,000 earnest money deposit, it just shows you a little more kind of what we call skin in the game. But generally, they're a couple $1,000s. And the escrow agent, you also have to name the escrow agent, and whether that's going to be Long and Foster or it's going to be, say, RGS Title as the escrow agent that actually holds the deposit, that actually takes the money, puts it in their account, and then the buyer gets credited back that money at settlement, assuming, again, there are no issues with that deposit.
Typically, the earnest money can be anywhere between 1 and 5%. Again, if there are different situations, let's say it is a bank-owned property or a short sale, then usually the earnest money deposit is less. In the paragraph 4, it also gives the buyer the choice whether they've delivered the deposit or will deliver the deposit. In Maryland law is how long before they have to deliver the deposit?
I believe under the contract it's now 3 days. You have to deliver it within 3 days. So I think they put this is actually new language as well. So I think what GCAAR wanted to do was to address the issues where you're writing a contract and your client just doesn't physically have a check with them, that you're going to write the offer and then you're going to deliver that check within a couple of days. If it's with a broker, so if Long and Foster's holding the deposit, the language in the contract says the broker must get it within 3 days, because the broker can't actually hold it. They can't not deposit it. They have up until 7 days to deposit it. After 7 days, if you're going to hold the deposit for more than 7 days, i.e. not have it deposited into an account, it's got to be held by the title company or a third party. So here, if Long and Foster is holding the deposit and you don't have it, you have to get it to your broker within 3 days, and then they would deposit it really immediately. If you want to hold the deposit, say after home inspection, you don't want your buyers to be out the money in case the home inspection comes back bad and they want to get out of the contract, and you don't want the escrow agent to deposit it, I would suggest always having the title company be the escrow agent, because then you can instruct the title company not to deposit it for a certain amount of time. So again, if there's going to be delay in depositing, then name RGS Title or your title company as the escrow agent there.
Our office policy is we want all contracts that are written to have the earnest money check written at the time, and once the contract is ratified, it be turned in ASAP.
Yep.
So we don't want them held for the 3-day period.
Right. And I would just say too, I mean, if you're a listing agent and you get an offer and you don't have at least a copy of the deposit, probably not as strong of an offer there. So you want your clients to be writing it, at least giving a copy of the deposit along with the offer.
Great point. We're going to skip to paragraph number 6, which is settlement. So when a buyer's writing a contract, Joe, how do they figure out what the settlement date should be? What should they offer?
Sure. Settlement date, really what I would always suggest a buyer's agent do is talk with the lender. If there's a lender involved, you have to understand how long it's going to take for that loan to process. So you don't want to put 15-day settlement in there just to get the offer, where realistically your buyer's loan is not going to be done for 30 days. So that would it wouldn't make really any sense to shorten the settlement date. So getting all the information up front from your lender as far as the timing of everything, how long to expect, and then you could put in a settlement date there. Normally, again, if there's a lender involved, it's normally about 30 days, 30 to 45 days. Again, some lenders might be a little quicker, some might be a little slower. So you have to understand what that lender's timeline is, because once you get past the settlement date, you're putting your buyer into a bad spot. So understand again what the loan process is going to be.
It's also important to check with the listing agent to look at basically, does the seller have any preferences as far as when they want to settle? Because that also helps to make a stronger offer. Right. The other thing is if you see there's a calendar there, to look at the calendar, and there are busier times of the year and busier times of the month that are not beneficial to the buyer to settle. I prefer that the settlements don't happen Monday morning and that they don't happen on Friday. You're dealing with lenders, and sometimes there are lender issues. What do you think about the end of the month settlements?
Yeah, I think that's a great point that you bring up. End of the month settlements. Everybody wants to settle at the end of the month, particularly the last day, because what happens is the buyer has to pay whatever month you settle in. The buyer pays basically the rest of the month in interest. So if you settle at the beginning of the month, they have to pay upfront all of the rest of the month's interest.
So on the settlement date, the most important thing to do is to understand it's a negotiating tool, that it's something that the buyer is putting down. However, it's important to check with all the parties just to be sure that it's a practical date. Take into account vacations and any holidays. As far as the settlement agent, that's the title company, the person who's going to be doing the settlement. In Maryland, the buyer has the right to choose the title company. We in this office use RGS most of the time because we know and trust them. Anything you want to say about that?
No.
Perfect.
No, I think that's good.
All right. Paragraph 7, the property maintenance and condition. In Montgomery County, all of our properties are sold as is, as of a certain date. So what you're putting in here is you're checking whether this offer is, as of the date of offer, the date of home inspection, or other. We recommend that if there's a home inspection being done, that it's as of the date of home inspection. Do you agree with me?
Yeah, and the benefit for having it as of date of home inspection is that you get a written report by a third party. So the buyer has the home inspection, the home inspector comes in, drafts up a report, and that report will generally tell you what the condition of the property is as of that date. If you choose another date, the difficulty is in figuring out what the condition of the property was as of that certain date. So date of offer, if you don't get into the property to determine the condition, there's nothing to go back to determine whether or not something has changed, where the condition has changed, and therefore the seller is responsible for fixing something or making any changes.
On paragraph 7, there are, on the second, right after the first paragraph, there are 2 boxes. One of them says this contract is contingent upon a home inspection, and it says that an addendum is attached. So if the buyer's having a home inspection, they would be checking that, and then there is a specific addendum, which we'll go over on another video, that they would have to attach. If the buyer's not going to have a home inspection, then they would check that. I would tell you, in this office, we strongly urge all buyers, whether they want things fixed or not, to take the opportunity to have a home inspection. We're going to skip down to paragraph 10, and paragraph 10 is the home warranty, and the buyer says yes or no. Sometimes sellers include the home warranty in the multiple listing service, and if so, then you would check basically that the seller would be paying for it. If the buyer wants it and they want to pay for it, they can check that they're paying for it. We have 2 home warranty companies, and you can check what the prices are and put them in here. Anything you want to say about home warranties?
Yeah, the only thing about home warranties is just remember, if you're on the buyer side and you're making an offer and the seller's going to pay for a home warranty here, and you check the seller box, and then you put in a cost, and it's cost not to exceed a certain amount of money, make sure that you know how much the policy or the warranty is going to be, because that's basically the limit of the seller's responsibility. So if you put in $400 there, seller only has to pay $400. If you get a home warranty that's $500, the buyer would have to pay the difference. So again, knowing what the costs are and what kind of coverage your buyer is going to want.
As a reminder, at the bottom of page 2, as in all the pages, there's a place for the seller and the buyer to initial. Remember that when you're preparing your offer, before you send it over, that the buyer does initial the bottom of the page. We're going to page 3, and on page 3, we'll start with number 11. Under the buyer representation, this is pretty important. The buyer has to say they will or will not occupy the property. So if the buyer's going to live there, they can put will. But if they're not going to live there and it's investment property, it's really important that they put that they will not. They also have a paragraph, the selling company is or is not authorized to disclose to the listing company, seller, and any lender the appropriate financial or credit information. So basically, it's allowing the buyer to be able to talk with the lender and the title companies, and also the listing agent. Okay. Paragraph number 12. So in Maryland, the wood destroying insect inspection or the termite inspection is basically not a contingency. It's something provided in the contract. Do you want to explain that?
Sure. You're right. It's not a contingency in the GCAAR contract. This language was changed recently too in the GCAAR contract. Now it used to be a checkbox where it said either buyer at buyer's expense or seller at seller's expense. Most of the time, if not, as you can see, except for the VA financing, if the buyer has a VA financing addendum, the buyer's going to pay for the termite or wood destroying insects for that test. So buyer at buyer's expense may choose to obtain a wood destroying insect inspection of the property. The thing to remember is, as Janice indicated, it's not a contingency here. So if that report or that inspection comes back with evidence of wood destroying insects, the seller has to remedy it. They have to fix it. There's no limit. There's no way the seller can then get out of the contract or void it under that inspection. So it is going to be a seller requirement to repair or treat the damage.
On paragraph 13, it talks about lead-based paint regulations. The law is that any house built prior to 1978 has to disclose the potential of lead-based paint. In this office, though, we recommend that all sellers fill out the lead-based paint form, the federal lead-based paint form, and just put down the year that the house was built. Again, after paragraph 13, there is a place for the seller and buyer to initial it, and completed lead-based paint forms are attached. Again, put yes, no, or not applicable. There's also a highlight of a link to the EPA on lead renovations, where so that your buyer and seller can be sure that they know what the regulations are. Number 14 is the financing application. Basically, this is just saying if this contract is contingent on financing, the buyer will make application for the specified financing in no more than 7 days. Then if there is financing, the appropriate financing addenda needs to be attached. Anything you want to add to that?
No, I'll just put, as you can see, there is a deadline in this financing application paragraph, so the buyer does need to make written application for the specified financing and property insurance no later than 7 days after the date of ratification. So that kind of goes back to that time is of the essence. And when we go over the financing documents, you'll see that's a specific potential default. So if the buyer has not done that within the 7 days, it specifies that as a default of the contract. So again, making sure you understand the deadlines.
Perfect. Explain alternative financing, which is in number 15.
Sure. So again, in paragraph 14, the buyer has to make written application for specified financing and any lender required property insurance. The buyer technically can then continue to shop their loan if they want, if they're looking for a better interest rate or something like that. And that would fall under alternate financing. So if they've picked a lender that doesn't fall onto the definition of paragraph 14, that's an alternate lender, it's alternate financing, and that's okay as long as the buyer makes the settlement date. Again, the buyer may substitute the financing or an alternate lender as long as the buyer's qualified. There's no additional expense to the seller, and the settlement date is not delayed, and buyer fails to perform its settlement except for any default by the seller. The provisions of the default paragraph will apply. So again, I think that the main thing to know, if your buyer continues to shop for their loan after that 7 days or as you're getting closer to settlement date, is making sure that the new lender can actually make the settlement date. Otherwise, it puts your buyer into a potential default situation. So making sure that, again, settlement date is not delayed, I think that's the key in the alternate financing.
Perfect. We're going to skip down to number 17. And Joe, talk about title, and because the title company obviously is very involved.
Sure, absolutely. So basically, our job is, as the title company, is when we get a contract, we have to make sure that title to the property is, quote, marketable and insurable. So basically, we just look for any issues involving the chain of title, whether there's any unreleased mortgages or deeds of trust, making sure that there's no other judgments or liens or bankruptcies or things like that that could affect title, or when we have to go to a third party to either get approval or get a payoff. We just make sure that the buyer is able to obtain basically an insurance policy on the property. And basically that would cover the buyer from any challenges or disputes of ownership, and it's a one-time fee. So they are covered for as long as they own the property from any challenges or disputes to their ownership or issues regarding the title of their property.
So in addition, the settlement date, basically the settlement company gives a settlement statement to both the buyer and seller. Is that correct?
That's correct. Yes. So is that the settlement? Yes. So we are authorizing that last paragraph, in the last sentence of that paragraph, to distribute a copy of the combined settlement statement. If you're new to the business, you don't know that there used to be a HUD-1. The HUD-1 went away for loan deals, and now we're onto a settlement statement. Your buyer gets a copy of the closing disclosure directly from your lender. And then at settlement, we have a combined settlement statement. So everybody's able to see the full transaction, all the prorations, all the payoffs, all the costs and fees. So we do share that as we get closer to settlement once that gets finalized.
On paragraph 18, at settlement, unless it's otherwise agreed to in writing, basically the seller's leaving the house and the buyer's moving in. Seller gives the buyer key. A rule to remember that all of the money from the lender needs to be at the settlement company. So my rule in the office is no cash, no keys.
That's correct. Yes, and Janice, you bring up a great point there too. There's elsewhere in the contract that talks about performance, and the fact is all of the money in Maryland has to be at the table. Loan money, buyer money, if the sellers are bringing money to the table, that all has to be there as well. So you might hear the term wet settlement. That's what a wet settlement is, that we have all the money. And we've gone now, and I could say with confidence that most title companies have gone to a wire requirement for buyers, unless it's under a certain amount of money. But generally, just assume that your buyer is going to get their bottom line cash to close, either from the title company or from the lender. They're going to get the wire instructions from the title company, and they're going to need to wire in their money. So don't have them go get a check at settlement. That's not going to fly really anymore. It's got to be a wire. So wire in, wire out.
On page 5, basically under number 20, it's saying that the broker's fee will be paid at settlement. It's on the settlement sheet.
All right, so the next few paragraphs deal generally with some legal language. In the adjustments, really just a notification to the parties that as of settlement date, there are some fees that get adjusted or prorated, taxes, HOAs, condos, things like that. So depending on the time of the year and when we settle, or even the time of the month when we settle, there'll be some money going from the buyer to the seller directly for repayment of some of their prepayments. Then disputes and legal expenses get into, again, obviously what happens when there's a legal dispute, and your buyer is going to want to read that, or your seller as well. They're going to want to read that as far as what their rights and responsibilities are. Performance, just a note, delivery of the required funds and executed documents to the settlement agent will constitute sufficient tender performance. Again, I referenced that previously. You got to have all the money there, and then you got to sign the documents. That's performance at settlement. Seller responsibility, agrees to keep existing mortgages free of default through settlement. That's an important one, just because if you are in a short sale and you know that the seller has not been keeping their mortgages free of default, you got to have that as at least to disclose it as a potential short sale if you're on the listing side. Because there's an affirmative requirement for the seller to pay their mortgage. And then default obviously is failure to perform. particularly at settlement. So if a party doesn't appear at settlement or doesn't have their money at settlement, you're in a potential default situation, and it goes through what happens again when one party is in a potential default situation. Just a quick aside to that too. I would just be careful as an agent making a determination or telling your client, yes, the other party's in default. That's a legal determination, and it's not a determination by you. If your client wants to declare the other party in default, I would strongly advise them seeking legal counsel, because basically that's gonna, chances are that might end up in court if the other party fights it.
So paragraph 27 is just a pure disclosure to the parties that really that they know what they've signed, that they know the information in the contract. It goes over a couple of things that the parties need to be sure that they understand as far as property condition, legal requirements, financing,
Nope.
broker, property taxes, property insurance, property insurance, and title insurance. There is a paragraph on 28 about assignability. It would have to be agreed by the buyer and seller to assign it to an additional person. 29, talk about foreign investment taxes or FIRPTA, Joe, please.
Sure. FIRPTA is a little complicated. FIRPTA basically says if you're not a U.S. citizen or a U.S. green card holder, the federal government might require the withholding of a certain percentage of the sales price. It's not even on net, it's on the actual sales price. If there's a question that you have about whether or not the seller, again, this is going to be on the listing side, if the seller is subject to FIRPTA, I would always suggest calling the title company or a tax advisor, or having them call a tax advisor or a tax attorney, because there are some other exemptions from it. But basically is if you're dealing with a foreign person for purposes of U.S. citizenship, there is going to be this foreign investment tax that you're going to have to deal with. And again, it's going to be either 10 or 15% of the sales price. So be very careful with that. It's obviously a lot of money that goes right to the government. The seller can always get it back or file a tax return to get at least some of it back, but it's going to be with the federal government for a little while.
On number 30, it goes through different definitions. I just want to, of all the definitions I want to talk, all of our calendars, unless otherwise written, are in calendar days. So it's 7 days a week, so that's something to be careful of. If we go through then to page 8, there are just some miscellaneous things here. And at the bottom of page 8, there is a place for both the buyer and seller to sign. The buyer will sign it, make a copy of everything, and usually scan it over to the listing agent with a copy of the earnest money deposit. At the bottom of this page, you see it says date of ratification. Basically, when both the buyer and seller have agreed to all of the terms and signed everything, the last person who gets it fills in the date of ratification. That date's pretty important because it's when the time clock starts ticking. It's when the time clock starts ticking for home inspections or appraisal or financing. And then at the bottom of the page, for informational purposes only, is all of the information about the seller and the buyer, and it helps the title company and everybody as they're processing the cases. And that's really our contracts. So stay tuned for additional videos regarding the jurisdictional addendum and all the other addendum and the financing. Thank you for visiting our house. Have a great day.